So my name is Micheal Hueston. I'm a defense lawyer. My office is in Brooklyn, New York. I've been practicing about 25 years. There's been an evolution. So we've had a number of administrative orders that have been put in place by the chiefs, basically the board of judges have come together. And so the best way to think about it, I think, are in terms of the courtroom access. So generally speaking, trials are not happening at all in Eastern and Southern District. So once March happened and the stay-at-home orders happened in New York City, really that sort of prevented trial practice in the state, excuse me, on the federal level. But some things were able to continue. So if there were bail hearings, or a host of those because of COVID-19. And so those were done through either video or through teleconferencing. So that became a large part of the practice. There's also plea practice, that does happen, but there is I believe there's a certain reticence on the part of not just the defense bar, but also the judges as well, because the plea process is such a key part in a criminal case where someone's now giving up their constitutional rights and they're basically testifying against themselves, and that's what a plea is. You are providing evidence of your own guilt. And most judges, unless something was pressing, is this something, in my experience, they've been pushing down to the point where they can do pleas in person. There also have been sentencings. And I haven't done any sentencing, but I know just anecdotally, talking with colleagues, that typically where judges were going to make a decision about time served, they wanted to do those sentencings now. And in that situation, it's in the client's interest to have the sentencing through a teleconference or through a video conference. Why? Because their client's going to get out of jail. But there's a reluctance, and I've gotten pushback from one judge in particular. I won't go into the specifics, but suffice to say that they didn't want to do a sentencing for a person who was not going to get the time served outcome, which is not maybe good news for my client, but that seems to what has happened in the course of of events with COVID-19. So, and then the other thing really that I've seen more than anything else, so you have bail hearings. There's a little bit of appellate practice. I'm about to have my first appellate argument on the 1st, for a denial of bail. And so that will go through teleconferencing in the Second Circuit. I think a practical concern is this. So for instance, I did an arraignment on the 17th. So that was the first arraignment I had done. And so typically there's an issue about logistics. So if I'm in court with my client and there's something that comes up and they want to give me information, we can do it off the record. We can whisper and talk, and that's that. Obviously, there's a difficulty in the teleconferencing circumstance. And I've had this happen a couple of times. So there's two ways to deal with the problem. One, you make sure you front end all those questions before the hearing. So there are no questions. So you've gone through every single issue. So on the arraignment, exclusion of time, or understanding that under the CARES Act and under the administrative orders that exclusion of time really doesn't count right now, which is an issue, frankly speaking. And does the person understand, have they gone over the indictment? Do they understand the charges? So, typically I can do that in person, but now I have to make sure, I don't see my client, so I'm interviewing them on the phone. I have to make sure they have the documents, and then I have to explain all these things to them. Now, how about if I don't do that? And we're in the middle of an arraignment, and the public's listening, and I have to go off the record. That's not something that's really doable, but the only way you can do it is honestly. So I had a situation at a hearing. It was for an arraignment on a superseding indictment. And the judge had given us a very short period of time for notice. My client's at the jail. And I explained to the clerk right up front before we even had it, I haven't had a chance to talk with my client. I need to talk with them about this. And that's the only way to deal with the problem. And I think most judges and clerks, they understand it. But the last thing they want you to do is not explain it and then sort of mess it all up. They'd rather you delay something, get it right, and then you can move on. And in that situation, the clerk basically removed everyone off the line except for me and my client, my associate. We talked everything through, and then we went. And then she said, I'll come back in 5 minutes and check on you folks. She came back, or 10 minutes, and then she checked on us, and we were like, we're fine. And that's how we proceeded. So that's the main issue, I think, that you have to understand. You don't have that freedom to navigate in a fluid way with your client. So you really have to prepare in advance about the pitfalls that normally come up. And there's also an issue in terms of, you can't read people, because some people are coming in by telephone. You can't read the judge as well. So sometimes you're not supposed to be talking, and you would have picked that up, but all those visual clues are out. So like I said, so you need to make sure your clients understand the information, the rights that you need to talk about, all those things that you would do confidentially. You have to make sure those are done. And you have to be honest if the technology or the circumstances are failing you. And to say simply, hey, there's a problem. Because you'd rather have the record right than have something embedded that's incorrect into what just happened. So that's what I think is the biggest practical concern, or the biggest practical concerns. Technology is great. One of the things I would like, so for instance, Zoom, we can share documents, share a screen. Then we need more of that for the incarcerated client. I have one client who I went through the Manhattan Treatment Court. That's a situation where a person's pled guilty, then has to do treatment, and then after that, the charges will get dismissed. But he's out. So there are times we could have this, our own communication, and I could show him documents literally through my own cell phone. I wish we need that for prisons. If this is going to persist, we need to be able to have information and documents that can be provided to them instantaneously. So I do think that sort of functionality needs to be heightened. It's not enough just for the person to see, all the images. They need to be able to see the documents, the speedy trial waivers, the indictments, and everything like that. Because other than that, you're relying on correctional officers or clerks to provide them with the information. I do think one of my takeaways, though, there's a certain efficiency, frankly speaking, to hearings, and there's certain hearings that really don't require all of us to travel. So, for instance, there are times when I'm literally traveling, to a court. When you think about embedded in that travel, it's like maybe an hour and 15 minutes of travel time, or whatever. For a conference, it takes 5 minutes. And maybe one of the takeaways is where we can, maybe we should do, this practice. So for instance, in that Manhattan Drug Treatment Court, the judge has apprised the client, you have a right to be there with your lawyer. Are you willing to give up that right? They understand it. But there, it's not a lot of controversy. So we can do this actually rather efficiently. So the client doesn't have to come from where they live. I don't have to come from my office, and we can get all the business done. And it's really a huge time saver. So I hope there's a takeaway from this, that we can save a lot of time and money on some types of matters. Now, obviously the main issue though that's coming up will be, trials. Now, only trials I've heard about happening was a SEC trial one of my students was part of, and that's a bench trial. So that was something that was able to be done, but that one aspect of it, there's no replacing. I know there was some talk about doing, jury trials by remote, but, frankly speaking, I just don't see how that would ever, I don't think that's workable for so many different reasons. If there's a collective body, if the idea of a jury is the collective wisdom, they need to sort of have a collective experience. And though remote world is, certainly some sort of collection and conglomeration of experience, it's not the same place of being in the same time and place. And people engage on different levels by video. It's harder to ignore something when you're in the room. I think it's easier when you're looking through a screen, frankly speaking. So, and I had one hearing, and it turned out to be fine when I think about it. It was a person who needed to go from one of the sort of a reentry center in Brooklyn and leave it because of COVID-19 and go where he was living. We had a house set for him in Virginia, and he wasn't from New York. So he was in a residential reentry system. And so he's at the hearing, and we had a good, I would say, very thoughtful judge, district judge, listening to the case, and there were facts he needed to say. And so I had to I made the decision that he should just say the facts about the conditions at the facility he was at. It was more like it was a hearing. So in essence, he was giving unsworn testimony about what was going on. Normally, I would have listened to him myself and then provided that information. We need to be thoughtful in this time and learn from it. So I appreciate you reaching out to me and having this opportunity. Thank you so much.